Congratulations, you finished the hearing. Now you may be asking, what's next? Your next and nearly last task is to reach a decision and prepare a written award. If you find in favor of the plaintiff, you need to decide how much money to award. Determining how much to award, if any, is guided by the plaintiff's request, the evidence, the parties' arguments about the evidence, the law, and your own common sense. If you are awarding damages to the plaintiff, here are some guidelines to help you calculate the amount of your award. What amount did the plaintiff ask for? The demand is at least a good starting point. If the allegation is for a breach of contract, what did the contract provide? What was the contract loss? If this is a personal injury case, are there medical expenses? Evidence of lost wages? If you find the defendant liable to the plaintiff for a personal injury, the Arizona jury instructions provide some additional guidance. What amount of money will reasonably and fairly compensate the plaintiff for the elements of damages proved by the evidence? Consider things like the nature, extent, and duration of the injury, the pain, discomfort, suffering, disability, disfigurement, anxiety already experienced, and reasonably probable pain to be experienced in the future. Reasonable expenses for necessary medical care, treatment, and services already incurred and reasonably probable to be incurred in the future. Lost earnings to date, and any decrease in earning power or capacity in the future. Loss of love, care, affection, companionship, and other pleasures of a relationship. Loss of enjoyment of life, the participation in life's activities to the quality and extent normally enjoyed before the injury. You have 15 days after the hearing to make a decision. Once you draft your decision, you need to notify the parties in writing and file a notice of decision with the court. You also need to return the original paper file to the clerk if you obtained it, and you need to notify the parties that exhibits are available for retrieval. You need to complete these tasks within 10 days after completing the hearing. Within 15 days after you file the notice of decision, either party may submit a proposed form of award to you with blanks for attorney's fees and costs. Within 15 days of receiving the proposed form of award, a party may file objections, and any reply must be filed within 5 days of service of the objections. Within 10 days of the deadline for filing a reply, the arbitrator must rule on the objections and file a signed original award with the clerk. If an award or stipulation for entry of another form of relief is not filed within 75 days after the notice of decision is filed, your notice of decision will become the arbitrator's award. If the notice of decision becomes the award, a prevailing party seeking costs and/or fees must file a motion to alter or amend the award no later than 90 days after the notice of decision is filed. You are authorized to rule on the motion, but the motion must be referred to the assigned judge for action if you do not rule on the motion or file an amended award within the latter of 170 days after your appointment or 110 days after a notice hearing. An opposing party may not file a response unless ordered to do so by you or the assigned judge. The non-prevailing party has 20 calendar days to file an appeal and submit a deposit with the clerk as required under Rule 77C. The assigned judge may hear the case or send it to alternative dispute resolution for a short trial. Once the appealed case goes to trial, the jury verdict or assigned judge's ruling in the case of a bench trial is considered binding. Rule 75G provides that, absent good cause, a party waives the right to appeal if they fail to appear or participate in good faith. You should document any finding that a party failed to appear or participate in good faith in your notice of decision or another notice filed with the court. How do I file my notice of decision or other documents with the court? Visit the Arizona Supreme Court's e-filing website for instructions. Do I get paid for doing the arbitration? Arbitrators are eligible for compensation for $75 per day for each hearing day. This means you get paid for any fact-finding proceeding or oral argument resulting in the filing of an award. You may visit the court's website for more detailed information about submitting your request for compensation. You are not required to request compensation. When will I be required to serve again? Arbitrators are appointed on a rolling basis from a list of qualified attorneys provided by the Arizona Bar. It is possible, but unlikely, that you will be required to serve more than one time each year. Thank you for watching our video series on the arbitration process. If you'd like to learn more, please visit our website at superiorcourt.maricopa.gov/arbitration or call our office directly at 602-506-1497. If you need to refresh your knowledge on the arbitration process, you may review Chapter 1 through 7 at any time via the YouTube playlist.